We are back on MorningLine. Thanks for joining us. Our final segment with Clint Kelly. And you're back for the first time in a while, so the calls will pick up. We've had a few this morning, 737-7587. But this is a great chance to call and ask questions about malpractice cases. And the cases move forward. And we talked earlier about lawyers sometimes just looking to settle, how money comes down and how things work out, or when you decide to litigate. And I think it's important to just talk about that portion of it. Settlement means you can wrap things up usually faster, right?
Yeah.
And if you can get a fair deal, I suppose most people would prefer to settle than go to trial. But sometimes, you got to push through.
Yeah. I mean, in these cases, I'm going to say probably about these days, 75% of these cases settle.
Okay.
Where I don't have to try the case. One of the reasons for that, Nick, is I try to pick the best cases I can.
Mm-hmm.
Cases that I know a insurance company, hospital, or physician will want to settle. All right, that's part of the equation, because at the end of the day, it's all about the lawsuit and the injury.
By the way, how do you notify them when that comes through and you realize this is a very strong case? Let's talk about, it starts with a letter, doesn't it?
Right, it's called a Presuit notice, which you must give within the year after the patient discovered the injury. And then there's a 60-day waiting period where nobody can do anything. You're supposed to negotiate, which is rare. But after that 60 days, then you can file your lawsuit. And oftentimes, Nick, I think I know what happened just from reviewing the medical records and having my expert tell me, what their take is. Then I take depositions, and it turns out to be something totally different.
Huh? Meaning
that
worse, better?
Sometimes better, oftentimes worse.
Okay, you found, really?
Yeah, because the medical records don't give you the texture or the flavor of what happened. You just read and you can follow sequentially what happened. It's like reading reading a play sheet, but then you find out what was actually happening, what people were saying to each other that's not recorded in the chart.
Yeah.
And so many times there's miscommunication between nurses, doctors, other healthcare providers, and those miscommunications are what lead to tragic, crippling injuries.
Are sometimes nurses key witnesses if they've seen something that just really upset them? And even though it's their own doctor, their own hospital, they'll come clean with saying, I can't believe what I saw in that OR, and I need to tell you? Or does that not happen very often?
No, it does. And actually, it's more common when you see the nurses who realize it's the doctor who screwed up. They are much more open to, they tell the truth, but they tell it in a way that informs you what happened as opposed to being cagey about it.
Yeah.
Whereas when the nurses know other nurses on their watch caused the problem, then it becomes, sometimes it's pulling teeth.
Yeah.
That's part of the art of being a medical malpractice specialist, is learning how to pull the teeth the right way to get the truth. That's, at the end of the day, we just want the truth. Better for worse, give me the truth. That's what my clients want. The clients want answers to what happened. Why did this happen? Why wasn't it prevented? There's sometimes where it can't be prevented, and the doctor didn't do anything wrong in the long run, or the hospital didn't, and they deserve to get out. But a lot of times they did do wrong, and the patients want to know why. Why am I in a wheelchair?
Sure.
Why am I losing my leg? Why does my son have brain damage? Why did my father die? That's what the lawsuits do, is they give these families the opportunity to get questions answered.
And you get settlements. You also know, as you're an advocate for your client, and you know what an injury is worth, I guess, based on your experience. So when an offer is made, sometimes you get some, and you immediately know this is absurd, it's way low. And maybe you can give me an inkling of, like, what's a leg worth? What's an eye worth? What's, and then sometimes you get offers that are quite good, but your client won't always accept it.
Right. Or in some cases, believe it or not, I've had situations where the client wants to take less than what I think the client deserves. At the end of the day, the client's the boss. But my job is to give as much advice and judgment possible to have the client make an informed decision. Take, for example, you're talking about what's a leg worth. I know that from prior cases where I've represented patients who've had amputations. You look at their age, what money have they lost in terms of earning capacity, medical expenses, what's it going to take care of them, what's the prosthetic going to cost. Some of these prosthetic limbs, Nick, can cost $60,000, and they only work for 3 to 5 years. So you have to replace them. So we build what's called life care plans. So if you got someone, say, that's 45 years old, you have to build a life care plan. Let's say it's a female, life expectancy up to age 85. You have to have a 40-year life care plan that funds the
replacements of the prosthetic?
Exactly, because what most people don't understand, your insurance companies will not pay, in most instances, future medical expenses when it's been caused by medical negligence. They have it's called a coordination of benefits clause in the insurance policy, and they're like, look, you got a lawsuit to get a recovery for this. If you get a major recovery, we're not going to pay for anything until that fund is exhausted. See, people think there's a double recovery. That's not true in most instances. Same with the government. Government has those written into law.
Right.
So that's a big part of putting a value on it. Plus, I can look and see what other cases have generated. I call other lawyers that do the same work I do and say, what were you able to get in terms of a settlement? The problem is we don't have as many jury verdicts anymore. So that's a part of the laws that were passed in favor of the healthcare industry. It's made it more difficult for people like me to go to trial and get a good verdict because there's so many legal hurdles to getting to a jury. And so we tend to, in some cases, settle cases that we might have otherwise gone to trial on because the laws are so difficult.
They've made it more difficult. Before we wrap things up, we've talked about a lot of cases and procedures that have changed how you're cared for medically, and I always think about the case you told me about Bill Paxton.
Yeah.
Great actor. You know Bill Paxton from Twister and others, just a wonderful guy. Goes in for a routine medical procedure and dies.
Right.
And I remember reading that thinking, wait a second, I forget what the procedure was he was having done, but it was something that you're certainly not going to die from. And he died. And I'm like, how? And then you explained it had to do with compression bandages on the leg that were not used. And I'm guessing since we've last talked, most hospitals have this as standard.
Yes.
But I mean, there was a time when they should have been doing it and they weren't. And that's something I'm always going to remember. If you're bedridden for a long time, you got to get something on your legs. You're going to get a clot that goes to your brain.
Yeah, most people don't know that when you are immobilized, bedridden for a long period of time, you have the chance of developing a blood clot in your legs, which can travel through your veins into your lungs and cut off the blood flow to your heart, and it could kill you. And this is something that hospitals now are very aggressive in trying to prevent. They will put these compression stockings on your legs. They have these look like inflatable balloons
that
around
move
your
it,
legs
right?
that move. Yeah, that's right. That keeps the blood flowing up and down the legs. That keeps it from pooling, which leads to the clots. And they also give you an injection of a drug called heparin. It's just a blood thinner.
Right.
And you put all these things together, and the idea is to reduce the risk of blood clot formation, which can be dangerous. And in Bill Paxton's case, it's not just him, it's happened in other cases. He didn't get the proper, what they call it in medicine, prophylaxis, which is just a fancy word for saying preventative medicine. He didn't get the right amount, developed a blood clot, and it killed him.
Was there litigation?
I don't know if there was litigation about it, because all I knew is there was a report of what happened. I know that the family's contemplating a claim, and I don't know whatever happened after that.
It goes without saying, at least in this day and age now, that would be standard of care, the compression bandages, meaning that if that happened to me and my wife hired you, you'd say, well, they didn't follow standard of care for Nick, we have a case.
Right. I mean, that's how it works. If I've got a patient who's been crippled, maybe they had an amputation because of a blood clot or died from a blood clot. In fact, one of the cases I got from this show, I don't know if you remember, years ago, was a widow whose husband was a general manager at a hotel, was in a hospital for 4 days. He was a high risk of developing blood clots because he was a big man, weighed about 300 pounds, died from a blood clot. And she called, and I found out he got no blood clot prevention whatsoever. And so he's laying there in bed, he's about to be discharged. An hour later, he leans up in bed, throws the clot, it kills him. And he had 4 minor children. I mean, it was just a crusher, and it was so preventable.
Oh, that's the big thing that gets you. 4 children, preventable. And when that happens, is it gross negligence? Is it that they didn't know? It's not that none of them want to kill the guy. So typically when these things happen, is it just negligence, someone not thinking or figuring someone else will do it?
You know, Nick, it's reckless. That's the best word I can use.
Meaning, like, I don't care, it's going to be fine, let's just move on. Let's take a chance, let's roll the dice.
Exactly, it's unsafe. The law calls it negligence, but nobody, I mean, that's really, from a practical standpoint, that doesn't move jurors. What moves jurors is when you can prove that the care was reckless. What I said by being unsafe. They do something that's unsafe, they just don't think about it, and then it causes a major injury or kills the patient. And those are the cases that I take, and those are the cases that you can win. The cases that are close calls or ones where, the patient might have been injured anyway, I can't take those cases because the jury won't find in my favor.
Gotcha.
And that case, by the way, the lady whose husband died from a blood clot, who was general manager at a hotel, we settled that case for $5 million.
Yeah.
And I thought that was a fair settlement under the circumstances, but it was based in part upon his lost earning capacity. The problem was the tort cap, the non-economic damages cap in that case, which was $1 million at the time. That's all you could recover for what the children lost.
Is that right?
Right.
$1 million.
So the $4 million of that was pure lost earning capacity, because the man was a 36-year-old general manager at a major hotel chain, was making six figures. He got that part of it, but I could only get $1 million for the children because the government cap will not allow me to get any more. That's where the cap's unfair.
Was that the only two things? Could you sue for mental anguish or suffering or anything like that? That doesn't come into play. It's
all wrapped up into one thing: his pain and suffering, the children's loss of his service, the wife's loss.
Okay. Yeah.
Don't forget, you had a marriage there that lasted 15 years. This couple was in love with each other. Think of what she lost in terms of the types of love and services he gave her. Because Nick, once you find the love of your life, it ain't easy to find another one.
Yep.
But anyway, all that is capped at $1 million, and somebody says, "Well, God, $1 million is a lot of money. You pay me $1 million. There's no way I'd trade my wife for $1 million."
Right.
I mean, that's just I can't even think of it. But that's an insult to me. And some things are, frankly, worth more than money, but money is the only thing we can come up with to call it justice.
And maybe get them to pay attention so it doesn't happen again.
Yes.
So, hey, listen, we just have a minute or two left. We may have the graphic that we can put up. Just explain to folks, if they call your office, how it plays out. And there it is. Again, it's over on East Main Street. It's a nice office. I've been there before, and they'll offer you a soda or coffee. That's one. And, of all the numbers we show on this show, that's the easiest to remember.
6158 million. You see it up there. That's why we did it, so people could remember it.
It's easy.
It's easy to remember. You call. You will speak to an intake specialist that we have who's going to go through a specific series of questions. I tell people always, please tell them what your injury is. It's so important for me to know that in order whether I can help you. I have to know what the injury is. And then they'll ask you what you think was unsafe about the medical procedure or the medical care. And then that information will be transmitted to me immediately. And if I think it's a case I can help, I have the client come to my office, or we can do it by Zoom. Nowadays, I'm doing a lot of conferences by Zoom. Even though my office is in Hendersonville, I take cases all over the state of Tennessee. I've litigated in Memphis, Knoxville, Nashville, Chattanooga.
You ever do federal court?
I have.
Yeah, federal as well.
I don't do as many of them because a lot of these cases are against defendants in Tennessee, so I can't get into federal court.
Gotcha. Well, you got the number. I'll put that up again for you there. Clint, it's great seeing you.
Good to see you again.
Good seeing you in person, in the flesh. We'll see you again in a month.
That's right. We'll do these regularly now.
Good show. It's a pleasure seeing you. We'll take a break. I'll be back with a programming note about tomorrow right after this.